Outside the High Court this afternoon, and a scene that's become all too familiar. There was the usual press scrummage at the end of yet another miscarriage of justice. But this time, the media that were there to greet them were themselves blamed for the main reasons for the wrongful imprisonment of Michelle and Lisa Taylor. Both girls seemed understandably daunted by their reception.
I'm too nervous, Lex. Go for it, Mish. Go for it, Mish. I'm with you.
It was Michelle Taylor who finally read the statement.
I'm with you, Mish.
We have spent 2 years of our lives protesting our innocence, and only now has the deliberate mistake of the police come to light. We will not say by being released justice has been done, because we should not have been put in this position in the first place. We also want to thank our legal team for believing us and working so hard to prove our innocence, and also to thank the Lord who gave us strength.
I would have thought that it would have taken them a long time to put this experience behind them, if indeed they ever can.
The Taylor girls were convicted in July last year of savagely murdering Alison Shaughnessy, the 21-year-old wife of John Shaughnessy, with whom Michelle had been having an affair. Michelle and Shaughnessy worked in a private clinic in Lambeth in South London. And it was said that in this house in Battersea, Michelle and her sister Lisa stabbed Alison Shaughnessy 54 times, a mistress's jealous fury. But today's clear decision of the appeal court found that the convictions had been unsafe. The case raises further uncomfortable questions about the workings of the criminal justice system. For the police investigation and the Crown prosecution took place long after the introduction of PACE, the Police and Criminal Evidence Act, designed to prevent the kind of miscarriage of justice which during the 1980s had done so much damage to the reputation of English justice. Crucial to the prosecution case was the evidence of Dr. Unsworth White, who lived a few doors down from the scene of the murder in Battersea. He told the original trial that he had seen two blonde girls leaving the scene at a critical time. But during the appeal, it emerged that the police had suppressed the doctor's original statement, in which he said that one of the girls was black, something described by the appeal judges as a very remarkable change of story. The appeal judges also criticised the police for suppressing the fact that Dr. Unsworth White had contacted the murdered woman's employers, a bank, who had offered reward money for information about the killing. Lord Justice McCowan stated Dr. Unsworth White's evidence appeared to come from an impeccable professional source, but he added, what a different figure he would have cut if the defence had had available the material which has now come to light. He also said the police had been completely wrong in deciding not to disclose this information to the defence.
This appears to be yet another case where the police have taken it upon themselves to decide what they shall reveal to their lawyers, and in this particular case the information which they had available was of such importance that they must have known that importance, and they would have known how helpful it would have been to us. They chose not to reveal it. It's their choice, their decision, and I deplore it.
Today, Dr. Unsworth White told Channel 4 News that he stood by his trial evidence. But what about the reward money?
I didn't really see any problem in at least discussing with the bank where I stood with regards to the reward. They asked me to write a letter to them, and that if the girls were subsequently convicted, then I should get in touch with them again. I didn't feel very easy about it even then, and I'm very glad to say that I received no money whatsoever.
Also today, the Liberty organisation said there were many other cases where important information had not been disclosed to the defence.
We think that there's probably 50 or perhaps more people who are currently in prison who have had an unfair trial because of the fact that evidence hasn't been disclosed to them.
The whole case also raises serious questions about newspaper coverage. For throughout the 3-week original trial, the tabloid newspapers in particular provided a coverage which the Taylor family and their lawyers thought was highly prejudicial, a view entirely endorsed by the appeal court judges today. The judges referred in particular to newspapers which had frozen a shot from a video of the Shaughnessy's wedding to make a peck on the cheek look like a mouth-to-mouth kiss. by rerunning the video, the real nature of the embrace is nothing like it had been presented. And the appeal judges have asked the Attorney General to decide what action should be taken against the newspapers.
We disagree totally with the judge when he accuses us of prejudicing the trial. We don't think any headline that appeared in The Sun or any photograph that appeared in The Sun could prejudice the jury.
The first thing the reunited family did after they got to their home in South London was spend some time in church. Tonight a big party is planned after a case which leaves nothing for the criminal justice system to celebrate.
Robert Parker.